we're going to talk about what you can do to help your child become lawful in the United States if you only have a green card. Green card holder parents, listen up. This video is for you. Who is a child? For immigration purposes, a child is someone who is unmarried and under the age of 21. It must be both, okay? Unmarried and under 21. Everyone else is considered a son or a daughter, adult son, adult daughter of a U.S. citizen or a green card holder. Let's do things a little differently in this video. Let's talk about a hypo to help frame this issue for us. 10-year-old son comes to the U.S. on a visitor's visa. The undocumented parent decides to keep the child here, and consequently, the child overstays the visa. The parent then marries a U.S. citizen and gets a green card that way. What are the options for this child? The first and best option for the child certainly is if the U.S. citizen step-parent can file for the child. But this can only happen if the marriage happened before the child turned 18. The child will then be considered an immediate relative of a U.S. citizen and can get the green card very quickly through the process of adjustment of status right here in the U.S., and the child will not have to go back home for an embassy interview. But what if the marriage didn't happen before the child turned 18? Let's say it happened between the ages of 18 and 20. Can the U.S. citizen step-parent still file for that child? The answer is no. The next best scenario for that child would then be for the green card holder parent to file for him or her. With the green card, guys, it comes with some limitations. And with respect to this process, the child will need to finish the process at a U.S. embassy because that child went out of status and did not continuously maintain a lawful status. And this is the frustrating part for many green card holder parents who think that their child who had overstayed a visa should be entitled to get in a green card here or eligible to get a green card here. For some green card holder parents, you may need to file for your child because perhaps the marriage is over and that U.S. citizen spouse of yours is no longer in the equation. And so you have no other option but to file for the child. And so you can do so, but just keep it in mind that the child will need to finish the process abroad because the child overstayed the visa. If the child has lawful status, however, then the child can go through adjustment of status. So what does this actually look like? So for instance, if the child came to the United States and the I-94 record is still active, it's still good, I should say, it hasn't expired yet, the child hasn't stayed longer than 6 months in the U.S., then the green card holder parent can apply for adjustment of status and the child can get the green card that way. Here are some common questions that we usually get related to this process. Will my child get a Social Security card? A child can only get the Social Security card if he or she had applied for adjustment of status. If only an I-130 petition was filed for the child and no adjustment of status application was submitted along with it, the child will not get a Social Security card, nor will the child get an EAD or the Employment Authorization Document. Consult with a lawyer friend to determine whether the child is in fact eligible to adjust their status through you, the green card holder parent. Another question that we get frequently is, well, can my child be added to my petition? I'm the parent, my spouse is filing for me. Can the child be added and get the green card with me? And the answer is no. If the petitioner's spouse is a U.S. citizen, if the child is eligible, if there's a step-parent, step-child relationship that was formed before the child turned 18, then the step-parent can again file for the child, but it has to be a separate process. The answer is yes, however, if the petitioner's spouse is a green card holder. But keep in mind that both the child and the parent will not be able to finish the process here in the United States through a green card holder petitioner if they had overstayed their visa. Friends, this is complicated stuff, okay? This is not easy to digest. Some people, they will need to work with a lawyer on this. We've helped so many families understand these issues and work on the cases for them. You can read our success stories to see all the different family scenarios, many of which are very, very complex that we've worked on. Go to McBeanlaw.com/success. Or if you'd like to meet with us, contact us at 516-866-3900 for an appointment. Just a reminder of the types of cases that we work on at McBean Law. We handle complex marriage cases or family cases, waivers, motions, appeals, cancellation of removal, adjustment of status in court, removal of conditions, naturalization, VAWA, domestic violence cases, U visa for crime victims, asylum, and many other types of immigration options. On the business side, friends, we work with qualified individuals to apply for a green card based on their accomplishments, their profession, or the fact that they're an investor. Others, we help with temporary visas for entrepreneurs, investors. We do H-1B as well, and some others. Before you go today, don't forget to subscribe to my channel as well as our firm's newsletter. Each week we send out terrific Q&As, good news stories, and our weekly immigration news summary. So go to McBeanlaw.com/subscribe. Friends, again, the issues that I've discussed in this video, they're not easy to digest at all. Some of you may walk away thinking, wait a minute, what did she mean by this or that? Speak with a lawyer, guys, about your unique situation and whether you are indeed eligible to file for your child and whether the child can get his or her green card right here in the United States without having to go back home. Thanks so much for watching this video. Comment below and I will see you in the next one. Bye-bye.